Well, hello everyone, and welcome to Uncivil Law, where as always we learn through the misfortunes of others. I'm your host, Uncivil Law, and we're here to talk about some events that have developed with respect to the riots and attacks that occurred at the nation's capital on January 6th of 2021. And I wish to state just very clearly that I, of course, do not condone any violence and I do not encourage violence. Violence is bad. You shouldn't do violence. You shouldn't go to places that you're not authorized, and you shouldn't disrupt things, and you shouldn't break things and stuff like that. So this is, as always, just a legal analysis of what happened that day and relative evidence that has come into play. But for the purposes of making sure that it's clear, because this has been a problem in the past, I want to make that clear. All right, so we're going to look at two things. We're going to look at an article that was written in which the QAnon Shaman, lawyer, said that he was not provided certain information in discovery. And then we're going to learn, we're going to see a filing that was just filed by the Department of Justice in one of the Proud Boy cases that somewhat responds to this allegation. So the Department of Justice has responded to this in a formal legal sense with respect to an ongoing prosecution. QAnon Shaman himself pled guilty and was sentenced to 41 months in federal prison. And to the best of my knowledge, that is currently happening. And we are going to look at this and try to assess what is going on in this case, try to assess what's happening, and try to give some remarks throughout. Okay. So let us go ahead and do that as I pull up the right window. All right. So this article is from, I'm not 100% sure, actually. Oh, well. The article says, an attorney for the so-called QAnon shaman, Jacob Chansley, asked federal prosecutors repeatedly for all the video showing his client inside on January the 6th, yet he's told the Daily Wire he never received bombshell and potentially exculpatory footage aired Monday night by Tucker Carlson. So he says that he requested all the footage, and he says that he didn't get all the footage. The Department of Justice has a different story. We will analyze. Albert Watkins, whose client Jacob Chansley pleaded guilty to felony charges of connection with the riot and was sentenced to 41 months in prison, were legally bound to turn over the footage. As part of discovery, assuming the case got that far, which is part of the discussion we can have on the legal nuance of the whole thing, as we try to reconcile the two positions, we can try to see if they can both be telling the truth at the same time. So they would be legally required to turn over the footage, but it's possible that that obligation had not yet occurred, depending on when the plea agreement occurred. Timing is relevant. Pressing on, however, clips show shown on the Carlson's Fox News program show Chansley walking freely and peaceably throughout the building, often accompanied by police officers. The attorney says we did not receive that video footage. We asked for it, and not just once or twice. Whether we asked for it or not is irrelevant, because the government has an absolute non-compromisable duty to disclose the video, and they did so. Well, debatable, but we'll get into the legal nuances on that as we discuss. And all the while, they were actively representing the court and the American people that Jake was the leader, leading the charge at the Capitol. They did not disclose the footage because it ran contrary to their rote narrative. Watkins, an attorney for nearly 40 years, so he knows what he's talking about, told the Daily Wire he was stunned to see the footage, which could have been used to defend Chansley. I've never seen anything so vile as I'm seeing right now. It's a departure from pretty high standards they've maintained for a long time. Anyone who needs to have belief in the integrity of our justice system, whether a left-wing New England academic or raging right-winger, needs to say this is wrong and effed up. Well, I will agree that, of course, that the standards do apply to everyone, for better or worse. It's one of the reasons why on this channel I try to give a neutral and fair analysis and try to look at evidence in the best light possible to a more complete story. So, like, I don't play favorites, right? I don't support the left wing when they were doing the Antifa thing, and they were doing a lot of things that arguably were more destructive And then in some senses, although again, you could get into quibbles about how you measure destruction. But let's just say that we're in the same, we're in a position where we could be talking about it, right? Where Antifa and the left wing and some other people did some things that were violent and destructive, occasionally with the arson, occasionally with some other forms of violence. And I don't approve of that. And I also don't approve of anyone who broke the law on January 6th of 2021. And I also want the standards that apply legally to apply to everyone equally, because that would be a good thing. So I will certainly agree that we should try to apply this evenly and fairly to everyone. Walker said the anger now being focused on Carlson for locating and airing the footage should be directed at prosecutors, who he says appears to have violated the rules established in U.S. versus Brady, which demanded that prosecutors must turn over relevant information in defense, particularly exculpatory evidence. Is this evidence legally exculpatory? It's questionable, but we'll get into it. Looking at the news, half of it is getting mad at Tucker. What the F does Tucker have to do with anything, except he's smart enough to get into your faces? It's appalling, he continues. Whether you're right-leaning, you like Tucker Carlson, you hate Tucker Carlson, is irrelevant. This is about putting a dagger in the heart of our justice system. And the person holding the dagger and thrusting it with all its might is Department of Justice. Nice imagery. I do like the imagery. This required collaboration from the top of the Department of Justice right down to the assistant U.S. attorney, lying to me, a fellow officer of the court, knew I had a duty to put my client in the best position I could based on evidence. Chansley pled guilty in 2021 to lawfully obstructing an official proceedings and no longer represents him. The U.S. attorney did not respond to the request for comment, but as I've mentioned, they filed some court filings that sort of respond to these allegations tangentially in a different case, but still, it's something, so we'll take it. So we'll look at what the Department of Justice has said in court on the issue. The federal judge who presided over the court should sanction prosecutors, according to Qanon Shaman's defense lawyer. This is an egregious violation of trust as I've ever seen, with the exception of hiding DNA evidence in a murder case. If I'm a federal judge and find out I was played a fool, I was duped by an assistant U.S. attorney that lied to me repeatedly while Watkins was yelling that no one was more peaceful than Jacob. And I made rulings based on what the government said. I'd be one pissed off federal judge. Yeah. Those issues should be considered in many of the cases still open. I'm sure they will be. The judge no longer has jurisdiction over the case. They said the remedy is a spatial writ of habeas corpus, and good luck with that. Our position is government must identify information it believes to capture defendant regardless of whether it intends to rely on the case in chief. Okay. So let's discuss some of the issues that are potentially in play. All right. First of all, the government has an obligation to provide you exculpatory evidence. So you can get into information about whether it's legally exculpatory or not. Right, about what it does show and what it doesn't show, because exculpatory evidence, strictly speaking, is evidence that would indicate that this is not the person who committed the crime, or it's not the crime that committed, right? It would tend to lessen the implications that this is the person or this is the things they did. And it's not really 100% clear that any of the evidence that's provided by Tucker Carlson is exculpatory in this legal sense, because I'd have to go double check the actual plea agreement. But as to the things that he pled to, it's not clear that any of the evidence is necessarily exculpatory in this legal sense. Because, I mean, it certainly doesn't go to question that he's the person. So it doesn't change that he was the person. And it doesn't change the things that he did. It may change what other people did, but those other people probably don't really, strictly speaking, speak to his legal liability for reasons that are fairly obvious if you think about it. Because the police escorting him around, assuming that that's what they did, is not legally exculpatory. And you might say to yourself, well, how's that possible? Because the police can, for better or worse, legally participate in crimes as long as they're not the ones encouraging the crime or they're not the ones instigating the crime, right? This is the idea of entrapment, right? So the police can participate in crimes, facilitate crimes, even as long as the actions that you, the criminal, are doing are voluntary, right? They can make it easier for you to do the things you were already going to do. That is the touchstone of entrapment, right? Were you going to do these things anyway? Are the police simply making it easier to do, or are they overriding your will? And so one way you can look at this is, for example, in the context of a drug deal, right? The police will knowingly pose as drug dealers or drug suppliers or drug purchasers, and they will enter into criminal transactions with people. They will just play a part. They'll just play the part. And you think you're talking to a drug user or a drug dealer or a drug supplier or whatever the case is, right? And you're doing this and you're like, but they're facilitating, and it doesn't work. Now, most of the time that's true, you don't know that they're a police officer. Most of the time they're doing this, it's undercover. But they don't have to, strictly speaking, be undercover, right? The thing that makes it legal or not is not the fact that they're undercover, right? Most of the fact you don't know that the time you don't know that they are a policeman. That information is being hidden from you. So here you know that they are a policeman because they're in uniform and stuff like that. But the legal analysis doesn't really change in this sense, right? If you went up to a uniformed policeman and be like, would you like to buy drugs? And the uniformed policeman is like, yes. Is like, can I do this? Sure. And he participates with you. Well, you're going to have a bad time. So the police don't appear to be doing anything in these tapes that are necessarily exculpatory, in the sense that it would undermine his legal responsibility. They don't seem to be directing him. They don't seem to be, and again, I mean, there's different ways of interpreting the tape, but it doesn't seem like they are overriding his will. It seems like he is the one that is acting, and the police are facilitating his actions, which, unfortunately, for better or worse, is legal. And then you're into an entrapment defense, and good luck with that. As you know, the police also were under no particular obligation, as you know, from our many discussions, to stop anyone doing anything illegal. The police have no affirmative duty to anyone in particular. They have no affirmative duty to protect you. They also have no affirmative duty, in most places, to act. So the police can watch you commit a crime, and you can know the police are watching you commit a crime. It doesn't make the crime legal, right? You might think to yourself, well, if it was illegal, surely the police would stop me. Well, one would think, but they don't, strictly speaking, have to. Now, they might as a matter of their policy, but they don't in a sense that impacts your legal case, right? So they might be violating some department policy. They might be violating their oath in some sense, but they're standing by and watching you commit a crime, and even like helping in some sense, as long as it's not overriding your will, is probably not legally exculpatory. Again, things can get more complicated than this. All right. So I'm not necessarily saying that everything I'm saying is the end all be all. I'm just simply trying to provide a reason why it might not be exculpatory. There are counter arguments to be had. I'm not trying to tell you there aren't counter arguments to have. I'm just trying to explain from first principles why what you see might not legally be exculpatory. Now, of course, there are counter arguments to be had. The police is, depending on exactly what the police did, that might be informative. And to the extent the police were encouraging, extolling, prompting, driving the action, now you're in a different sort of analysis. But to the extent that they're more passive, just facilitating, just watching, just whatever, it doesn't really, and even their active participation isn't enough necessarily, as I've been pointing out with the drug deal example. So even them actively participating, whether you know they're a police officer or not, right? The police can lie to you. They do it all the time. So the police saying, yeah, this is totally fine, doesn't make it legally fine. The police helping you doesn't make it legally fine. The police being passive doesn't legally fine. The police walking along with you as you walk down the corridors of Congress doesn't make it legally fine. So it's not clear that it's exculpatory in any proper legal sense. Might be, but not clear. All right. Issue number 2, discovery. All right. Depending on exactly where we were in the plea agreement and exactly what the plea agreement is contingent on, this is going to get down into the particulars. But the discovery is a part of a court proceeding. Not all court cases make it to discovery. Not all criminal cases make it to discovery. Sometimes the government makes a plea deal very fast before discovery. Now, as long as you know that you're doing that, that's valid, because you have to make a knowing, intelligent, voluntary waiver of your rights. And it's like, we're willing to make this deal now, says the government when they come to you. It's like, we're willing to make this deal now, but if you wait till discovery, the deal's off the table. Now, it might be because they're trying to hide something in discovery, but of course you don't know that. It also might just be because they're trying to be dicks or put pressure on you, ticking clock, psychological tactics. So it could be that. So there's nothing necessarily improper about the government withholding information, as long as you're not far enough in the proceeding that's required and they haven't lied as part of the process. They can't lie to you or like, we've given everything, when they haven't, right? They can't make material misrepresentations like that in court, right? What the police can do and what the Department of Justice can do are not the same thing, because attorneys have ethics rules that police do not. So attorneys cannot make material misrepresentations. The police can. So in some senses, the police are more free than the U.S. attorneys, because the U.S. attorney can't do as many things as the police can, because they have different roles. So one of the things you might wonder in sort of doing this analysis is, what stage of proceedings were we in? What representations were made? What promises did they make? What did this guy know in terms of what he was agreeing to or not agreeing to? In terms of what was provided or not provided? Now, this guy's lawyer has made some representations in this article about these things, and he should be taken seriously. He's a 40-year attorney. He's worthy of being taken credibly. It's worthy of being taken credibly. So I don't want to be unduly dismissive. Again, I'm just trying to explain how things may be proper when they appear to be improper. Just because the government didn't give the information doesn't necessarily mean the government did a wrong thing, because things might depend on what I said, like where we are in the proceedings, what representations have been made, and so forth and so on, right? So all those things. Okay. So with all that in mind, I thought what we do now is we would read this governmental response of sorts. This was just filed yesterday in the ongoing case of United States of America versus Ethan Norden, who is one of the so-called Proud Boys. Ethan Norden over here has taken note of these tapes that have come to light in the proceedings of Tucker Carlson, and he has cried foul. So he has moved to dismiss or have a mistrial with respect to his case because of these factors. Again, the Qanon Shaman case is closed because the plea deal. So if he wants to upset his case, he's going to have to go to appeal or go to do a habeas or something. But this guy is trying to upset the apple cart while things are still live, which he has a right to do, and the government has filed a response. So I thought we'd read the response. Jeff Hayes says, is in a plea agreement a contract? Yes, it very much is. Plea agreements are contracts. Yes, there are a few considerations on top because of constitutional considerations, but if you view plea agreements as contracts, you're there 98% of the way. Yeah, they're contracts. They're just special kinds of contracts. But yeah, they're contracts. That's basically what they are. So let's read this stuff. In his filings, the defendant moves the court to dismiss the case against him due to recent revelations on the Tucker Carlson show that purportedly prove that Congress overreacted when members of the mob have overrun offices, broken windows and doors, and were roaming free through the Capitol building, began pounding on the door of the House of Representatives. From there, the defendant asserts the case against him must be dismissed because the prosecution has been monitoring attorney-client communication defendants, sounds sketchy, destroying evidence, and doctoring and fabricating evidence, including confidential human sources. That all sounds really bad. What does the government have to say about this? Once tethered to facts and reality, the defendant's arguments have quickly unraveled. First, all the footage of Jacob Chansley that aired on Tucker Carlson earlier this week has been produced to the defendants in discovery. So as to this particular case, the government is making the representations, and again, they're not allowed to make material misrepresentations. They're saying it has been produced to these defendants. These defendants have seen this footage, or at least it's been made available to them, whether they've seen it or not. So I will take that at face value. Second, there's been overwhelming trial evidence of the dangerous riot at the Capitol, which was brought about and through the actions of the defendant, his co-defendants, and others. Third, the attorney-client communications in question were not privileged, having taken place on an overtly monitored jail email system, and have been available to the defense since they were produced in discovery. So, again, this is not new information. Yes, we have your emails that you sent to your attorney. We have your emails. In fact, we've provided them to you. We provided them to you, the emails, because the emails were sent through the email system, which clearly says that it's being monitored. So it's not privileged because you knew people were looking, including, importantly, the government. So, yeah. Fourth, other claims of misconduct have no basis in fact. For the reasons set below, this motion be denied. The government has produced videos shown on Tucker Carlson to these defendants, again, to these particular defendants. According to public reporting, in or around February 2023, the Speaker of the House of Representatives granted Tucker Carlson access to a wide range of U.S. Capitol surveillance footage related to the events of January 6. Beginning Monday, March the 6th, Carlson's show began airing portions of the footage. Based on what was shown on television, the defendant now asserts the government withheld certain footage of Jacob Chansley, who pled guilty. Then the footage was exculpatory, creating a Brady violation. All right, let's give that a shot. The videos were produced in discovery. The motion describes shocking footage of Chansley walking calmly through the halls of the Capitol, with two police officers who purportedly escort Chansley and apparently other protesters into the Senate chambers. Yeah. The defendant quotes Chansley's former attorney for the proposition, the government withheld this footage from discovery in these cases. The government says the footage is not shocking. It was not withheld from him or Chansley in any material respect for that matter. Okay. What exactly does that mean, not withheld is questionable with respect to, because it's a little bit different than has been provided. Not withheld isn't quite the same thing. So we can quibble on the word choice, which we should because it's lawyers. But it hasn't been withheld from this defendant. And in fact, it's been given to this defendant. Also not withheld from Chansley. As to Chansley, what exactly does that mean? Footage in question comes from the Capitol video surveillance system. The court will be familiar with the clips that have been introduced as exhibits during this trial. The footage is court evidence in nearly every case and was produced en masse, labeled by camera number and time to all defense counsel in all cases. And there's a footnote saying the productions excluded a limited set of footage that Capitol Police designated as security information, such as X-ray machine feeds and views of evacuation routes and sensitive compartmentalized information facility lobbies. So, yeah. $5 super chat says, as far as I'm doing, all they're doing is talk at this point. The DOJ saw no proof to refute him other than the statement. I'm going to take the Department of Justice at their word. because I believe in my profession and I believe in what they're saying. I will read what they're saying with precision, but I'll take them at their word. So when they say, in this particular case, they say, that they were produced in discovery of June 2022, I'm going to take them at their word that that's true with respect to these defendants. Okay, where were we? With the exception of one camera where said footage approximated 10 seconds and implicated an evacuation route, all the footage played on television was disclosed to the defendant by September 24th, 2021. So now they're making a representation that it was disclosed to QAnon Shaman guy by September 24th, 2021. I suppose the next logical question is, when did QAnon plead guilty? Let me find out. Said plead guilty. Let's see. In November of 2021. In September 2021, he apparently agreed to plead guilty. In November 2021, he apparently pled guilty. So the timing is questionable here, because apparently it was September 2nd that Jacob Chansley agreed to plead guilty. But it might not have been until September 24th that the information was disclosed to Chansley. But that, of course, doesn't necessarily, as I've been mentioning, form a problem with Chansley. Right? As long as Chansley knew that the information hadn't been provided, as long as they weren't lying to him, as long as they were being honest about what they were doing, as long as he knew what he was waiving, you can plead guilty in the dark. Incidentally, I'm not sure that, as I've been saying, the new evidence really does anything to undermine the guilty plea for the technical legal reasons we've been talking about. But, there's that. So he wasn't provided the information maybe until 2 weeks after his plea deal. But if he knew that, then, oh well. The final 10 seconds of footage was produced in global discovery on January 23rd, 2023. The Brady claim therefore falls to the threshold because nothing has been suppressed. While discovery in this case is voluminous, the government has provided defense counsel with necessary tools to readily identify relevant cameras within the system to determine whether the footage was produced or not. Accordingly, the volume of discovery does not excuse defense counsel for making reasonable efforts to ascertain whether an item has been produced before making representations about what was and was not produced, let alone before filing an inaccurate information. There is a lot of discovery. There's a lot of footage. 40,000 hours, I think someone said, which, from when you take all the cameras and all the footage, probably is about right. So there's a lot of it, but the government has to disclose it to you and you have to figure it out. And they labeled it and did things. And so, it might be totally proper. There may be some irrelevant cameras. There may be some irrelevant cameras. So, because some of the it depends how you define irrelevant, I suppose. But there might be cameras which show absolutely nothing. There might be cameras in which it shows a hallway and all it shows is a hallway and all it ever showed is a hallway. No one ever went by or through there. Or there might be cameras that show nothing. So there might be some irrelevant cameras, but okay. Faith Walker Todd says people were suing to view the footage. Depends what you mean by that comment. Do you mean in the context of a FOIA, a Freedom of Information Act? They were suing in that sense? Well, FOIA won't work because the information is held by the Capitol Police, which is a legislative agency. And FOIA is for the executive branch. So I'm not sure what you would use to try to get information from the Capitol Police if it can be done as a member of the public. Even if it were foiable, it still wouldn't be disclosed because it relates to an ongoing law enforcement investigation. So first of all, FOIA doesn't apply at all because it's not an executive agency. Secondly, even if it did apply, it would relate to ongoing law enforcement activities and would probably be withheld under that reason. So when you say people are suing, do you mean members of the general public? Because their ability to get information and the defendant's ability to get information are two completely different things. The defendants were suing for it. That doesn't sound logical. Why would they sue for it? That doesn't make any sense. But okay, they would what? That doesn't okay. Why the sounds okay? The possession of videos is okay. The videos are not exculpatory. The defense possession of videos is dispositive of the claims. Nonetheless, the record should make clear the videos in question are not exculpatory of any participant. In fact, the videos of Chansley's movement throughout the Capitol are highly inculpatory and other rioters. As to his legal liability, yeah, they're probably not legally exculpatory for the reasons we've discussed. The argument seems to be that snippets of the movement were televised, established there was no emergency necessitating the suspension of proceedings. That's rubbish. The television footage lacks the context of what occurred before and after footage. Chansley entered the building as part of a violent crowd that gained access as a result of defendant's destruction of a window, and he traveled with him during the initial breach. And just as defendant Biggs had recounted in a recorded statement after January 6th, by the time the defendant forcibly breached the Capitol and Chansley rode his coattails, the mob, through sheer force of size and violence, had wrestled controls of portions of the Capitol ground and the Capitol itself from vastly outnumbered police forces. I think this is roughly true. This is roughly true. As a result, for most of the period of that afternoon, for the videos to be exculpatory, all they have to do is show the other side of the story and show the defendant did nothing wrong. He did many, many things wrong. Chansley did many, many things wrong. He broke the law. As a result, for that period, those defending the Capitol were in triage mode, trying to deal with the most violent elements of those unlawfully present, holding portions of the Capitol that not yet been seized, and protecting members and staffers who were still trapped inside. Yeah. Chansley piggybacking on the defendant's violent breach of the Capitol proves more than enough evidence of corrupt intent to interfere with Congress. But there's much more evidence of his and others' conduct. The televised footage shows Chansley's movements only from approximately 2:56 to 3 o'clock. Prior to that time, Chansley had, among other acts, breached a Capitol line at 2:09 with the mob, entered the Capitol less than 1 minute behind the defendant during the initial breach of the building, and faced off with members of the United States Capitol Police for more than 30 minutes in front of the Senate chamber doors, while elected officials, including Vice President of the United States, were fleeing from the chamber. Chansley then entered the Senate gallery, where he proceeded to scream obscenities, while other rioters rifled through the desk of U.S. senators on the floor below. All these actions were captured by Senate floor and/or CCTV cameras. In sum, Chansley was not some passive, chaperoned observer of the events for roughly an hour that he was unlawfully inside the Capitol. He was part of an initial breach of the building. He confronted law enforcement for roughly 30 minutes just outside the Senate chamber. He gained access to the gallery of the Senate along with other members of the mob, obviously precluding the Senate from conducting its business. And he gained access to and later left the Senate floor only after law enforcement was able to arrive en masse to remove him. The evidence is all available, exploration. I don't know what you are refusing to accept the evidence that's available. The evidence, we've seen the evidence. You know the evidence. You know exactly what the evidence is. Don't pretend like you don't know. Don't be purposefully dumb. And then exactly this is right. A crime is a crime regardless of who aids or abets you. Correct. Yeah. So yeah. The doors had magnetic locks which could only be controlled from the side. Who had access? Well, as the government just told you in the document we've just been reading, some of the people, including this particular defendant, apparently broke the windows. And incidentally, in our prior footage, we've covered some of that, where we've seen the defendants break the windows, go inside, and open the doors from inside. So, again, we've seen this evidence. In any event, Chansley's circumstances do nothing to mitigate the defendant's criminal exposure. The trial record is replete with video, audio, and testimony proving the defendant's egregious conduct on January 6, which includes viciously assaulting a Capitol police officer, forcibly taking that officer's riot shield, threatening other officers, using the shield to shatter the window, and then with Chansley engaging in a standoff with the Capitol police inspector mere steps from the Senate chamber. Incidentally, for what it's worth, I'm not trying to make global claims. I'm trying to look at this nuancedly, and maybe that's where some of the chat is having some conniption, so let me clarify. I'm not trying to make any global claims. I'm not trying to claim that every single person who entered the Capitol building did so by breaking a window. I'm not trying to claim that everyone who entered the Capitol building did so by breaking a door. I'm not trying to claim that everyone who entered the Capitol building did so because one of the other people who entered the building got inside and opened the door and the person who entered knew about it. I'm not trying to make global claims. It is definitely possible, with respect to some of the people involved, that some of the people were ushered into the building by police. Those people would have a claim. Those claims do not extend to everybody. So perhaps the confusion is that people think I'm making a global claim when I'm not, right? We have seen evidence. We have seen the evidence of people breaking windows. We've seen the evidence of people going inside. We've seen evidence of people assaulting police officers, including with a fire extinguisher. We have seen evidence of people behaving violently. We have seen evidence of destruction of property. We've seen people behaving in all kinds of reprehensible and very criminal and sometimes violent ways, assaulting officers, doing all kinds of shit. But of course, not everyone is equally guilty. That would be insane. Everyone's case has to be assessed onto its own merits. Some people may, in some sense, not have done anything wrong. Some of them maybe. I don't know. I haven't assessed 1,000 different cases. I don't know. We've assessed on this channel when we did the Capitol Riot series, we assessed something like 50 plus. And of the 50 plus we examined, we found one where it's like, okay, I don't think the government has the case. But the evidence against the other ones were pretty good. That isn't to say that that's necessarily indicative of everyone. It's indicative of the 50 we reviewed. Of those cases we reviewed, at least in my personal assessment, government had it in all but one. Does that necessarily mean that that ratio would hold? Of course not. Every case has to be assessed under its own terms. So if you want to say that some people, didn't riot, if you want to say some people didn't do things, then that's fine. Maybe they didn't. I don't know. We can only assess one case at a time. What I am telling you is with respect to these particular people, we've seen the evidence of their particular crimes. And the government's not making this shit up. Maybe that's the issue. And you could also agree, you could also make the case that the media exaggerated January 6th. Now, I think the fact that it is the nation's capital in somewhat mitigates that, because I do think personally that an attack on the nation's capital is of a more serious nature than an attack on some bodega. So while arguably many of the riotous events which occurred in the great wide world during that summer of love, which we've heard so much about, are arguably more destructive, I think you can make a case, and I would make the case, that an attack on the Capitol is a difference in kind. So even though it might not be as severe in some senses, it is more severe because of the nature of the location. The nature of the location makes the action more egregious because it's the seat of government. And I believe in the peaceful transfer of power and so forth and so on. And it is constitutionally mandated. And so you're interfering with a constitutionally required process, which pisses me off. Now, you can, of course, disagree with that assessment, but that's my assessment. That being the case, however, all that being said, you could still make the case that the media oversold January 6th. I think that's a credible case because, it's 9/11 times a million. It's not that. It's yeah. Some perspective would have been helpful. So I think trying to make the case that the media and the media narrative and even the Democratic narrative has been, what should you say, has been not in keeping with perhaps all of the underlying reality is a case that is worthy of making. That, of course, does not much to help particular individuals who committed crimes, but still. The trial record overflows with evidence that Dominic, or the defendant, obstructed, impeded, and interfered with the Electoral College proceeding. The evidence has shown, among other things, that the joint session was convened at 1:05, as required by law. The Senate and House separated into their respective chambers at 1:14 to resolve an objection to certification. As required by law, the debate over the objection shall last no more than 2 hours and shall be put to a vote, and once the two houses have voted, shall again meet immediately. Again, yeah, if you're trying to sell me that some of the people who did some things got less than they deserved, you don't have to sell me on that proposition. Some of the people who did some things got less than they deserved. I think it's a fair proposition. A lot of the people who did a lot of things during the summer of love got a lot less than they deserved. I'm not sure that in and of itself is relevant, though, because what is the argument? Because they got less than they deserve, these people should therefore inherently get less than they deserve. Now, what they deserve is a matter of, again, individualized assessment in keeping with the criminality as it respects to each particularized person. So I don't think you can swipe everyone off with the one fell swoop. But I don't think just because someone else got less than they deserve means that these people should get less than they deserve. I mean, I think it means everyone should get what they deserve. And the fact that that didn't happen means justice didn't happen in those cases. I don't think it means that we shouldn't do justice in these cases. The counsel for defendant asserted the government has steadfastly refused to identify in what way any of the defendants directly caused the recess of the joint session. It's hard to conceive a defendant better suited to assess his personal contribution to obstruction than the defendant. Nice line. The uncontroverted evidence in this trial has shown, among other things, that the person used a riot shield to break open a window adjacent to the Senate wing door and enter the Capitol building through a broken window. The Senate was ordered into recess by Senator Grassley, and immediately after Senate recess was called, Senator Langsford was advised that protesters were in the building. Members of the mob then continued to stream into and remain inside the building, including hundreds that entered through the Senate wing door and adjacent windows that had been violently breached. Their actions and presence obstructed, influenced, and impeded a joint session of Congress. In testimony, Kevin McCumber provided further evidence as to the effect of the rioters on the joint session. Exploitation Random Destination said, "Why won't the Fed step in and charge those from using explosives and firebombing law enforcement? I don't know. You'd have to ask them. It makes me mad." Yet pursued grantings for January 6th, clear and absolute bias. I don't know why they didn't do those things. The fact that other people are not getting what they deserve for their own criminality makes me mad. I don't know why the feds made those decisions. Political reasons is the most obvious, but I don't know if it's beyond that. All I know is it makes me a little bit angry. But I still am going to assess each case on its own merits, including this case. What did or did not occur with respect to any other defendant has precious little to do with this particular case. As the record reflects, Mr. Rogers' route asked only arguably the Senate could have continued for a few more minutes, to which McCumber replied the House continued for 7 more minutes before recessing. The defendant's role in obstructing the certification is a mystery in its own one. Yeah, I think they've got him. Oh, the Senate could have waited longer before recessing. What kind of argument is that? And apparently, one of the people had their license to revoke, license to practice law. Jonathan, who's this guy? Where's footnote 7? Hate having to find a footnote. Always hard to find a little notation. Okay, there he is. In a motion, the defendant claims the FBI had been monitoring privileged communications of defendant Real and his prior attorney, who apparently got disbarred. We could look into why, but maybe we will. That could be fun. The government has not obtained any privileged information between defendant Real and Mosley. As the government explained in a separate filing, Real and Mosley made fully informed choice to communicate with another over a monitored jail email system. In doing so, they waived privilege. And I'll do it. The government further assesses that the undersigned prosecutors have not reviewed the communications in question and have no knowledge of their contents beyond what counsel introduced in open court. Moreover, it's unclear how a purported violation of rights would require any remedy with respect to the defendant because there's no joint defense agreement. Again, what happened with respect to any other defendant is irrelevant. What happened in any other case is irrelevant. Every case has to be assessed under its own merits. So whether or not the government violated some other person's attorney-client privilege, which the government says no because they knew it was being monitored, so no. But even if they did, it has nothing to do with you. You have no standing to raise the issue. It's not you. I know. What do I know? I only know what I can prove. I can guess. I can take hypotheses, but I don't know. I don't know. How would I know? How do you know? Yeah. Maybe you misunderstand what it means to know something. Finally, as noted in the government's separate filing, even if one were to set aside the explicit acknowledgement that communications over monitoring systems are not privileged and assume, among other things, that the jailhouse communications could be said to retain some sort of privilege, the defendant has not made a showing that he suffered any injury from the collection. No standing. Rather, the counsel chose to engage in a monitored system. The counsel for defendant asserts that he identified messages that describe destroying evidence and doctoring and fabricating evidence, including confidential sources. The government has explained in separate filings the messages show nothing of the sort. For the purposes of the filing, the government disputes the nefarious conclusion the counsel seeks to tease out of the messages. Further, the government notes that contrary to assertion by counsel, the messages bear no relationship to the alleged intrusion, and thus it is unsupported by facts. So, yeah. That's interesting. And let's take a quick look at this barment proceeding and see if I want to get into this. Let's see. This is for Jonathan Mosley. All right, Mr. Mosley, what did you do? MOSE. Jonathan Mosley. Violation of rules that govern safekeeping of property meritorious claims and contentions, candor towards tribunal, fairness to opposing party, unauthorized practice of law, multi-jurisdictional practice of law, bar admission and disciplinary matters, judicial officials and misconduct. Exciting. How long is this thing? Let's see. Looks like some fee stuff with a trust count. Looks like some failure of candor with respect to investigations into his trust account. He placed unearned funds for his own use. That's a no-no. So it looks like some client funds mismanagement. That'll do it. That's a problem. All right, cool. Stole from clients? Yeah. So I'll try to answer some of your questions, even though I'm sure you'll drive me nuts, but I'll try anyway. I will try to interpret your questions as being in good faith and go from there. Let me check, first of all, to acknowledge all the super chats. And let's see, super chats. Let's see. Today is March the 13th. Today, the messages is from Creative Chaos said, I'm always glad to hear your analysis of an event. Exploitation said, far as I'm concerned, all they're doing is talking at this point. The DOJ has shown absolutely no proof to refute Tucker Carlson other than the statement. Firebombing NYD cars 1 year and a day in prison. Why don't the Fed step in and charge those using explosives and firebomb law enforcement, yet pursued grannies? Okay. So all those things. So I don't see anything here that is immediately concerning. The laws may need to be updated. That might be true, but for better or worse, the laws are what they are, and I can only talk about the laws as they currently exist. If you want the laws to be changed, talk to a politician, not to a lawyer. Tuning in EDB. You're not the same as when you started. That's okay, whatever. Though I still support you, I'm not watching this one. I don't think I've really changed very much, Della. Or to the extent I've changed, maybe my presentation's gotten better. I've become sharper, hopefully better as a presenter, hopefully better as a YouTuber. Incidentally, this tonight, I'm doing my first scripted video. I'm not sure is really good, but I wrote a script. I've never done a scripted video on this channel before. I have like 1,800 videos and none of them are scripted. I wrote a scripted video. I don't know. But I'm doing one tonight on Tom Girardi and the California bar report that just came out. It's a 9-minute long video. It has a lot of like stock footage B-roll in it. So we'll see how that all goes. So you can look forward to that and let me know how that goes. So that should be interesting. I have improv tonight at 7 o'clock. That's true. The thing is tonight at 6, I think. The one that's scheduled to go out. Become better, become more comfortable. Become better about telling people you don't agree and then moving on. Yeah, I get less bogged down by it. That's true. How do we fix selective and possibly political enforcement? I'm not sure how you would do that. I don't know how you would go about doing that, even in principle. I'm not sure how you would go about doing that. Why'd I feel the need to script this one? Not that I felt the need to script it. I'm just trying to do something different. I'm experimenting, as one does in their YouTube career, trying different new things. I scripted it because I wanted to see how that worked. So I scripted it. So we'll see. I'm Central Time. It's 5 hours and 15 minutes from now. What fun lawsuits am I excited to cover? Whatever the US Supreme Court is doing, there's some good cases coming down. What do I think about the destruction of Chevron last week? What destruction of Chevron would you be referring to? I'm sure Chevron is still alive and well. Do you mean with respect to the US Supreme Court asking questions on the student loan thing, on the major questions doctrine? That's what you mean by destruction of Chevron, man, Lord. How about the banks getting shuttered in California? I have no particular information or knowledge on that. I'm not an expert in the field. So I don't really have anything particular to say about the shutting down of banking in California because it's not a legal thing. I mean, there are laws that apply, but you already know the laws that apply. I mean, the accounts are insured by law, and so the people with accounts will be made whole, and the bank fails, and I'm not sure about that. My take on the Crumbly parents, I don't I have questions about whether or not they can be held legally responsible. I understand they appealed on this basis. Be interested to see what the courts say. I'm not really sure I see the factual basis for their legal culpability. The House had a meeting on reining in the Chevron doctrine. Well, it's a start. 96% of SVB's holdings were uninsured funds. Well, then the people who had those funds, sucks to be them. So I have really nothing to say about it. I'm not knowledgeable in the field. Can I cover powerlifting versus J.C. Cooper? Hmm. Why do we say cases coming down when it's the highest court? Because it's the highest court, so it's coming down. Because if it's the highest, then it comes down. So I think you answered your own question on that one. How have I been? Pretty good. I'd rather be Supreme Court for sure. But Chevron is a case that gives a lot of power to administrative agencies that I don't like. I think it was a bad decision from the US Supreme Court. I've talked about it before. I seem good? Thank you. The House was discussing the waters of the United States thing. Cool. Some sort of congressional action in that domain wouldn't be good. Yeah. President of the United States is a bad deal. President of the United States is a bad deal. Supreme Court kicks ass. Who wants to be president? Just a bad deal. A lot of vacation time. That's true. Biden has been taking some vacation time. I'm not, yeah. Yeah, you go up to the Supreme Court and then their decisions come down. So what's coming down from the Supreme Court is what goes up must come down, right? So the case goes up and then I'm waiting for what comes down. I'm still not sure. We're apparently having a dispute on up versus down right now. I'm not sure how we got into this discussion. Did I push another 2,200 pounds today? No, I did go to the gym yesterday though, and the day before, which was pretty badass. And I do need to go today, so I'll probably go after this stream is over, so I can get my workout on. That'd be good. I had a good workout yesterday. I pushed like 20,000 pounds or something. I didn't post my workouts. That's true. I didn't. I didn't post my workouts the last couple times I went to the gym. That's true. It's a little inconvenient. I have to log in and then change my account and blah blah blah. It's a little inconvenient to post my workouts, so I didn't bother. All right, I'll sign off. I'll sign off for now. So this will automatically redirect you to the thing tonight, so you can enjoy that. That will be in about 5 hours. I'm excited, sort of. We'll see how it goes. I think it's fine. It's just like, I don't know, maybe it needed more takes or something. Just doesn't quite have the same level of energy I think I normally do. But it was also a way to experiment with more B-roll and experiment with different editing and stuff like that. So I figured I'd give it a try. So we'll see how it goes for all of it. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.